couple of quick questions that did drop in here. Try and get through a couple of them before we wrap things up. But this one dropped in a number of times during the presentation, so don't know who wants to take the lead on this, but it just asks, what are the implications of the potential unavailability of PGR and IPR when it comes to biosimilars?
I mean, I could, this is Scott Cunning, I could jump in. The IPR and PGR obviously meant to be more cost-effective means of challenging patents, and with the large number of patents in these portfolios, I think it has serious implications, and that it's going to be very difficult to litigate through to successful conclusion on all of the patents that could be asserted and not have a single claim that would be held to be valid and infringed, especially as we wade into the biosimilars that are newer, unlike the older products where the patents that were being litigated were the sort of end-of-life patents and a life cycle management strategy, lower value patents that were easier to avoid. The newer patents are not going to have that same issue. Although overall, I just think it's kind of unlikely that these patents would be exempted from IPR or PGR review.
This is Karen, also from just in general, the IPR process has been very important to the biologics and the biosimilars in order to, like Scott was saying, to kind of get rid of the weak patents and try to cull down the patent thicket prior to engaging into the BPCIA patent dance and litigation. So it's a very important mechanism for biosimilars. Also, from what we're seeing in these antitrust litigations is that there's a lot of reliance on what happens in the IPR as a basis for whether or not subsequent litigation is brought as a sham, whether it was objectively baseless to bring subsequent litigation. So I think it would be a great disadvantage to the industry if those two processes were not available anymore to industry competitors to be able to take advantage of, because certainly it does have, although there is a lower standard of proof that you have to go through in the IPR, it does have tangible, significant benefits to both sides in moving forward through the patent dance and litigation.
Thank you so much. And this final question before we wrap things up, just asking our panel how they feel the new Biden administration could impact the future of the BPCIA. Is there any expected or anticipated impact of the BPCIA, if I can get my words out, as a result of the Biden presidency?
I was going to say, this is Scott, that I tend to not focus too much on the bills, legislation that gets proposed on this. So, for example, limiting the number of patents, like cutting back on whether or not IPR or PGR is available, forcing or perhaps not cutting back on whether it's available, but the proposals to force either small or large molecule stakeholders to choose one pathway or the other, to either go district court or to go IPR, PGR, but not both. These bills change so much that if you evaluate every one and its possible implications before they actually come through committee and get passed by both houses, it's sometimes not the most efficient use of your time. So I'll leave the predictions to maybe one of the other panels.
Yeah, this is Eric. This is Eric. I agree, Scott. What's interesting, and what I would encourage our listeners to do, however, is to also keep an eye on what's happening in the state legislatures. There's been some movement on the commercialization end of things of late, where certain state legislators are looking at ways to promote biosimilar uptake. So while I don't have any predictions on how the Biden administration may take actions that would impact the BPCIA, I do think certainly things are young, and there's a lot of motivation to try and further push biosimilar uptake, and some of that may come from the state legislatures.
Just real quickly, this is Trang. The only thing I have to add is just I think looking forward to seeing who's going to be the new PTO commissioner, just to see, for instance, like if the trend on discretionary denials kind of gets carried over to the next administration will be interesting, particularly because obviously in a lot of these biosimilar actions, as well as under Hatch-Waxman, there's a lot of parallel litigation in both district court and before the PTO. So any sort of policy that's moving forward that kind of curtails that will obviously impact the ability to clear patents early before a substantial investment, or even to kind of make to do litigation more efficiently.